Call the matter of Bernice DeJesus versus Rex Drummond, file number 25-20119 DP. Ms. McCoy, could you please place your appearance on the record?
Yes, Your Honor. Good morning again. Jennifer Dustin-McCoy on behalf of Rex Drummond, who is present via Zoom.
Thank you, Mr. Drummond. I do see you. If you could just please unmute real quick and confirm that you can hear me okay.
Yes.
Thank you. And then Ms. DeJesus, I think you are present also. Can you hear me okay?
Yes.
Guys, today we're diving into a real courtroom moment where a father pleads for time with his 5-month-old baby.
Thank you. All right, this is an initial hearing regarding custody, parenting time, and support. Ms. Dustin-McCoy, do the parties have any agreements on those issues?
Not at this point, Your Honor. The parties did have a consent judgment affiliation entered. I think potentially we could reach an agreement if we went to mediation. Right now, my client isn't receiving any parenting time. The party's daughter is about 5 months old now. And so one of the things we had wanted to ask on the record today is if we could try to get some temporary parenting time until we have mediation or until our next hearing. But I think the first step for us procedurally would be to set up mediation and then have an evidentiary hearing if we need to.
Thank you. Ms. DeJesus, what are your thoughts on participating in mediation?
I believe that the best approach right now is to do consistent daytime supervised visits with my daughter, so she can bond with her father in a positive and secure way. I'm committed to reevaluating as she grows and her needs change. And I agree as well, if we cannot agree today, I would respectfully ask the court to order mediation so we can work with a neutral third party to help us plan a development for her that supports her development needs and strengthens her relationship with both parents.
All right, so we'll definitely do that referral for mediation, and if mediation is not successful, we'll schedule an evidentiary hearing. So, ma'am, it sounds like you're willing to agree to some type of temporary parenting time until you guys get to mediation. Is that correct?
Me?
Yes.
I'm supervised visits, if we can do that.
Right.
And I would also ask,
who would you anticipate as the supervisor?
either I can be a supervision, we can meet in a public place, just because she does not know him. And she has different needs than other children. She's not just a baby that has, and then from there on, we can increase time and he can go without supervision. But until mediation is done, I would like to have a supervised visits.
Right. So, Ms. Dutz-McCoy, are you willing to entertain that as a temporary agreement pending mediation?
Well, I would have to ask my client about that, Your Honor. Rex, did you hear what Ms. DeJesus had just stated?
Yes.
And what are your thoughts about that?
I mean, I've had her unsupervised before, so I don't see a reason why it would have to be supervised now. That I haven't given her any reason for me not to have it unsupervised or supervised by my parents or someone else, just so I can have her at my house and I have to meet at a public place to, so I can have some quality, one-on-one time with her.
May I object?
Well, it's not formally an objection, but yeah, you can certainly, state your opinion on the matter, ma'am.
So he has never had her alone. I've made sure that he was supervised by his parents the 2 times that he has seen her for a short amount of time, for 2 hours. During that time, he did seek my advice. Multiple text messages came through. And when she did return, she had she had poop on her skin that can really result in infection. And I did let him know about that. So that's where my concern is, that why he needs, he cannot be under, I'm sorry, I'm getting nervous, her supervision alone.
Well, may I ask, would you be agreeable, Ms. DeJesus, to parenting time with Mr. Drummond's parents at his home, or at their home? You meet at a public place to exchange your daughter, and then those visits be during the daytime until we reach mediation?
Not until we reached mediation, because he was under supervision of his parents during that time that he was messaging me, and she came back home with the fecal matter on her skin.
So you wouldn't be comfortable with him having supervised visits by his parents until we reach mediation?
Until we reach mediation, because of those concerns, yes. Because he did not know what to do the times that he had her for the short amount of times, yes.
So am I understanding that you're not comfortable with any kind of supervised visitation until then?
I am comfortable with supervision under my supervised visits, like under me, just for, just to make sure that she is secure and safe, and um, just for her overall safety, and make sure he is able to care for her. Just her stability is what my concern is.
Where would those take place?
We can come to an agreement.
So it could be a location that the two of you agree upon.
Yes.
How long would the visits be?
We can agree from 2 to 4 hours at those times.
What days of the week would that be?
It could be the weekend or the weekday, preferably the weekend for my time. That would work best. I do have sorry, if that is something he would.
And would it be one day a week, multiple days a week?
We can start for one day a week until we reach mediation, and we can go by stages in mediation, and from then we can discuss the stages. And like I said, we can reevaluate as her age grows and she is more developed in her developmental stages, and her nursing is less frequent.
Rex, would you agree to, let's say, a 4-hour supervised period, maybe a Saturday, maybe another day convenient for you, once a week until we reach mediation?
Yes. But she says as we agree, but she hasn't texted me back in 2 months, so it's kind of hard to make plans and schedule when she, she has read receipts on, so I can see that she reads my texts, and then, hasn't texted me back for 2 months, so I just don't know if she's going to text me back to, end up meeting.
Okay.
I
think
am
the
requesting.
thing is we would, a minimum of 1 visit per week supervised by Ms. DeJesus, or an additional supervisor if the parties agree. And obviously, this is the minimum, so if things go well on that visit, perhaps things will change and you guys can work in additional visits, but a minimum of 1 visit. Mr. Jesus, can you commit to a 4-hour visit once a week?
Yes, on the weekends I can. I do have full custody of my daughter and 80% of my son, so that's why I'm requesting the weekends.
Rex,
All
would
right,
it,
so it's gonna be,
sorry, Jordan.
go ahead.
I was going to say, would a day on the weekend work for you, Rex?
Sundays are mostly open for me.
Okay, so Sunday afternoon, perhaps?
Yeah.
Okay, so what if we did Sundays from 1 to 5?
Yep, that would work.
Sundays do not work for me.
Okay, what about Saturday for you, Rex?
I'll make whatever work. So
What if we do Saturday 1 to 5?
Yes.
Okay, and then, the location, can we just agree upon a location, on a temporary basis?
yeah, I mean, anywhere's fine. Doesn't,
Okay.
know,
What would be your preference, Ms. DeJesus?
I have a park right by my area, so if I need to bring her home for any emergencies, I can come home as well.
Okay, so what if you agree to meet at the park if it's nice weather, and then if it's not, that you return to your home?
Yes, that's fine.
Do you agree with that, Rex?
yeah, I mean, it'd be nice to not have to sit, it'd be nice to be in a public place or not have to sit at her apartment to see my child for 4 hours in a small living room.
Okay. Okay, so then we could do that on a temporary basis until we attend mediation and revisit the issue. And that would start this weekend, on Saturday?
Yeah, that's fine for me.
Yeah.
Okay. All right, so what I have down is there will be a 4-hour period from 1 o'clock to 5 o'clock on Saturdays, supervised by Ms. DeJesus or an agreed upon person. That you'll meet at the park by Ms. DeJesus's residence, and that you may return to her home during that time period, for the remainder of, parenting time. That'll start this weekend on Saturday. We'll continue that on a temporary basis until we go to mediation.
Are you good with those terms, Ms. DeJesus?
Yes.
Right,
I
could you
did want to
please-
ask if there is a texting app that the court offers that we can communicate through, or if there's a way that we can communicate through the court only.
Ms. Dukes McCoy, any thoughts on using an app?
So my experience with parties lately has been via app close, which is, I think, a free application for both parties. And those conversations can be produced and presented to the court. I've done that in the past. If the parties are comfortable with using that, that would be one that I would recommend to the parties.
The mother demands every visit be supervised, while the father fires back saying he's done nothing wrong.
Mr. Drummond, any issue with that?
Nope. No, Your Honor.
All right, anything else, Ms. DeJesus?
No.
All right, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I swear.
Thank you. So, Mr. DeJesus, you've heard the terms laid out by Ms. Dukes McCoy regarding this temporary pairing time arrangement. Are you in agreement with those terms?
Yes.
As well as to use the app close moving forward with your communication?
Yes, I do need to know what exactly her app she is referring to.
It's
APPCLOSE.
Okay, app closed.
That this is a temporary agreement, so it doesn't prejudice anyone's rights moving forward. And in your mediation and any agreement you reach there. Ma'am, do you believe this agreement at this time is in the best interest of your child?
Yes, but I have to ask, is it going to be 4 hours every Saturday, or is it 2 to 4 hours every Saturday?
I believe the agreement that Ms. Dukes McCoy put forward was 4 hours every Saturday.
4
Yes.
hours every Saturday? Okay, I just wanted to make sure.
Okay.
Okay,
And
yes.
obviously, if the two of you can also expand that if you feel it is appropriate. Mr. Drummond, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And sir, are you also asking the courts to enter this temporary agreement that's been placed on the record?
Yes, Your Honor.
I know you don't agree necessarily with the amount of time, but given where we're at, do you believe that this time that this agreement is in the best interest of your child?
Yes, Your Honor.
Thank you. All right, so we will prepare that temporary order, also do the referral to mediation. And again, if the parties don't reach an agreement at mediation, then we would set the matter for an evidentiary hearing. Anything additional, Ms. Dukes McCoy?
No, thank you, Your Honor. Thank you for your time.
All right, thank you, and thank you for your assistance. And Mr. Jesus, anything additional?
When do we go forward with child support as well?
Okay.
There's
That has not yet been determined, Your Honor, and I don't know that there was yet a referral to the front of the court, but because we don't have a specific parenting time order, I don't know that we can calculate that at this point.
I've been the
Well, I
sole
think-
provider with no
court-
assistance.
Let me take a look through the filings. We certainly need the parties to provide their financial information if they haven't.
We would need updated information for both parties.
Okay. So the complaint was a maternity complaint.
Yes.
I would refer the matter for a support recommendation, certainly, given the request today, we would do a referral with an effective date of today's date. And obviously, at this time, that's based on 0 overnights, but as that changes, then a new support rec would be prepared, or potentially tiers prepared if it's kind of a gradual assessment. So the parties do need to provide updated information to the front of the court. So if your caseworker reaches out to you, make sure you take that call and provide that information, okay?
Okay. It would be dated from the time of the complaint, right?
No, I'm dating it from today's date, ma'am.
Oh, because I filed a while ago for child support, but he put in a for custody instead. So that's why they referred it over here, because he did not want to submit to it. So I've been the sole provider for my child for the last 5 months, financially, everything.
I do see a paternity complaint. I don't see a specific request in the paternity complaint saying to begin support. So you're making that request certainly verbally today. So I'm going with today as the effective date.
Okay, if I grab that information for you, can I submit it again to the court? It was through the.
So what happens when it's prepared, you have the right to file an objection. So I
Okay.
would save it for that. And if you've got supporting paperwork that shows that we should go further back in time, you can certainly make that consideration, or perhaps the parties could even stipulate, but for what I've got in front of me today, that's going to be the recommended date, but again, you will have the right to object to that, okay?
Okay, I will object because there was a complaint.
Okay, ma'am, thank you.
Thank
All
you.
right, we're all set today.
Thanks.
For our next call, matter of Melissa Klein versus Dustin Price, file number 11-14071 DS. Do we have the parties on that matter present?
Present.
Ms. Klein is present. Is Dustin Price present? All right, if you are present, you do need to unmute yourself so the court can know you're present.
Present.
Thank you, sir. All right, we're here today. This matter was referred to the front of the court following a denied ex parte motion filed by Ms. Klein. Ms. Klein, what change are you seeking to make?
Well, right now, as it stands, I don't have any set parenting time with the kids. So that's kind of why I filed the motion.
Okay.
So
What type of parenting
basically,
time schedule are you looking for?
what's that?
What type of parenting time schedule are you looking for?
Well, this is my concern. My concern is because of what happened with him and Emma, that he's maybe has too much stress on him. So my thought process is having a set parenting time schedule will alleviate some of that stress on him. Right now, how we're doing it is, or how we were doing it, he was allowing them to come over whenever they wanted to, or whenever I didn't work. However, it worked out, which was fine, and it worked really well. But now I'm thinking that maybe he had too much of the responsibility. Obviously he's getting to the point where he's getting stressed out and getting kind of violent or whatever. So I'm like, okay, well, maybe we need to have some set time where he's getting a break and they're coming over to my house, staying overnight. And maybe that'll alleviate some of the stress on him. When I first
Okay.
filed the motion, I asked
what set schedule are you looking for?
So I think that 50-50 would be okay. I'm not
Okay.
trying to take the kids from him at all. That's not my plan. I just don't want this situation happening again. And I don't, yeah.
Mr. Price, are you in agreement with making any changes?
I'm sorry, what was that?
Are you in agreement with making any changes?
I mean, I don't really agree with making any changes, no, and I feel like the situation between me and my daughter was blown out of proportion. I think as it was perfectly fine.
Okay, so if there's no agreement, what we would do is we can proceed one of two ways. One, we could set the matter for mediation if you think the two of you could get somewhere through mediation and come to some type of agreement. If you don't think that's possible, then what we would do is set the matter for a court hearing. And then each side could present their arguments on whether or not changes should be made and what those changes would be. Ms. Klein, what are your thoughts?
Well, can I tell you my concerns?
We're not
I,
gonna match, I can't make a decision today, so it's just whether or not you guys want to participate in mediation or we set it for a court
well, I mean, I'm open to trying to come to an agreement with him if he is, but if he's not, then yeah, we're gonna have to go to a judge.
hearing. Okay. Mr. Price?
Yeah, I'm okay with mediation. I guess I don't understand why something needs to change when there's not an issue. I've never stopped her from seeing the kids, and she's had open visitation with them to see them whenever she wanted.
Okay,
So-
I'm gonna set the matter for a hearing because my concern is, there might not be any give going on, so I don't wanna take a step that's not gonna get us anywhere and then just delay the matter further. So Ms. Klein, do you intend to represent yourself at a hearing?
I'm not sure.
Okay. I just
As
asked
of right
because-
now, I don't have a legal representation, so
Without a lawyer, I usually set it for a 1 hour hearing. With lawyers, I'll often grant more time. We can come before the court for an hour hearing in November. If more time is needed, we'd be looking at December. Mr. Price, do you intend to represent yourself or hire an attorney?
Represent myself.
All right, so let's set it for that November 19th date. It'd be November 19th at 11 o'clock. That is a in-person hearing, so you both would be here in person. Given the ages of the children, they would also meet with me prior to the hearing to do what's called a preference interview. That's a confidential meeting.
The judge steps in trying to calm the storm, pushing them toward a fair compromise before mediation.
So they would need to be here at 10:45, and then someone should be available to either take them to school or take them back home. Additionally, if you intend to call any witnesses or provide any exhibits, you need to file what's called a witness and exhibit list. Additional information will be in the notice that you get for the hearing. If before then the two of you talk and reach some type of agreement, you're certainly free to do so. You're also free to reach out to community mediation on your own if you think that might be helpful for the two of you prior to that hearing date. And we will see you back here November 19th then for the hearing on the request to change parenting time. Any questions, Ms. Klein?
no.
Mr. Price, any questions?
No, sir.
All right, thank you both for appearing. I'll see you November 19th.
Thank you.
Stephen Bugner versus Whitney Vroman, file number 15-15711 BP. Next, call the matter of Ava Cole versus Reese Laporte, file number 24-19913. Do we have the parties on that matter present?
Yes, Your Honor.
Thank you. Both parties are present. This matter was referred to the front of the court following the plaintiff's ex parte motion to change custody and parenting time. I do know there was a order put into place, looks like in July of this year. So Ms. Cole, what changes are you looking to make?
I do have a speech prepared if I could read that at this time.
Well, no, thank you. I'm just trying to get the basic facts. This isn't an evidentiary hearing today. So what changes to that July order are you looking to make?
I can't get to the thing. It won't slide.
So that July order indicated what his parenting time would be in September, October, November, and then moving forward in December. So what change are you looking to make?
I would like that sole legal and physical custody be granted to me and that Mr. Laporte's parenting time be suspended or alternatively restricted to a court-appointed supervised visitation only with a neutral third party and a temporary custody order to protect against unlawful withholding or abduction.
All right, and why are you requesting those changes to the order?
There has been a lot basically that has been going on. Reese has routinely failed to bring proper supplies, including incorrect diaper sizes. He hasn't brought formula or bottles at times for Clover, including dinner items for both of our kids. He doesn't attend to basic hygiene needs, and I've had to intervene to care for the children myself during visits. He's shown a clear favoritism towards Carter while ignoring Clover, refusing to take photos of her during previous visitation, and since motioning the courts, he has taken minimum photos of Clover. And since then, he has participated more with Clover, but leaving Carter to spend more time with his grandma. And he's repeatedly brought unauthorized visitors to visits without advance notice, despite acknowledging that this would interfere with his one-on-one parenting time. He brought his girlfriend to a visitation despite me expressly stating that it was not appropriate, and did so anyway, showing a disregard for co-parenting boundaries and the emotional needs of the children. And Carter has level 3 autism and global developmental delay. His care requires consistency, therapy, emotional regulation strategies, and educated responses. And Mr. Laporte has never participated in Carter's ABA therapy, speech therapy, occupational therapy, medical appointments, developmental discussions. In fact, he even admitted via text that he can't even handle the stress of checking in on the children during the week. I did have to call the police at our first visitation because Mr. Laporte was being verbally aggressive. And this is not the first instance where he has been verbally aggressive with our past with domestic violence. He has had 2 domestic violences where I was named the victim, and there was 2 other reported incidences with documentation already submitted previously when I was
Alright, so
pregnant with Carter, where he
I'm
put his
just gonna
hands on
focus
me as
on what's
well.
happened. Hold on, man. For the purpose of this
Okay.
motion, we only focus on what's happened since July
Okay.
of this year. So
Okay.
some of those things that listed prior to going into the domestics, those were things that have happened during the visits since they started.
There was one incident where I had to call the police. It was call for service number 3477. Basically at the first visitation, Reese allowed Carter
That's okay,
to
man. So you issues, I understand that that was at that visit. And then the other issues, when you mentioned, you know, the care of the children, you're saying those things, those concerns have happened on the visits that have started since July?
yes, all of this.
All right. Mr. Laporte, are you in agreement to changing your parenting time or disagreement?
Complete disagreement.
Okay, then we'll set the matter for another hearing.
Your Honor, my only concern is that Reese is supposed to start his alone parenting time with the children, not this month, but next month. And with Carter's autism and the way that Reese is not prepared for this, and I am not okay with him having the kids alone overnight.
All right, well, as soon as I can get you in for a evidentiary hearing is December 3rd at 1 p.m. That is right before his December parenting time switches to every other weekend overnight.
I believe that November starts Saturday night for the whole 24 hours.
It does, ma'am. And I know you did not, I don't think objected to that July order. You have the right to file, you know, an additional ex parte order if you think you have additional information that might persuade the judge to stop his parenting time. But I can't make any changes myself until there is a evidentiary hearing. So I'm going to set you guys for December 3rd at 1 p.m. Again, that is a in-person hearing. If you intend to call any witnesses or file any exhibits, you would have to file a witness and exhibit list again. That is due 14 days prior to the court date. Any questions, Ms. Cole?
Is this an evidentiary hearing with you or is this with the judge?
This is an evidentiary hearing before me, yes. Any questions, Mr. Laporte?
No, sir.
All right, thank you both for appearing. You were all set.
Thank you.
And in front of the court, what is the status of this matter?
This hearing has been adjourned 3 times, most recently from August 20th. The defendant was to make a payment from her paycheck she received from her last employer, and was to contact friend of the court and update once employment was obtained. It does appear from an income withholding, a payment dispersed on August 26th in the amount of $77.01. The defendant's obligation is $114 and a balance on the account of $513.99. There has not been any additional payment or contact since that hearing.
Thank you. Ms. Roman, what would you like to say?
Yes, sir. I did have an interview at the Iron Pig, and I'm going back there on Monday to meet with the owners. And they said they were going to bring in all the paperwork for me.
So you did have a job in August, but that job is gone?
No. Oh, it was the Panera bread.
So you don't have that job?
No, I ended up having to go to the hospital, and by the time I got out, they stopped putting me on the schedule.
All right. So when do you anticipate that you might start work?
Hopefully Monday.
All right, I'm going to set you out a month so that we can get that update. I'll adjourn you to November 5th. Same thing applies. Obviously, if you get work, you got to let your caseworker know immediately so the paperwork can be done. If you get any paychecks that take place before the income withholding order is in place, you got to make sure you make your payments directly. If this job doesn't work out, then we're going to want to hear that you've made other efforts when we come back on November 5th, okay?
Yes, sir. Thank you.
All right, thank you. You're all set for today.
Thank you.
Court next calls a matter of Danielle Provan versus Travis Ackerman, file number 11-14113 DM. Do you have anyone present on that?
Yes, I am. Danielle Proven.
Thank you. For the court, what is the status of this matter?
The defendant has a monthly support obligation of $470 plus $50 ordered on arrears. The current balance is $9,758.14, with the last payment received in June of 25 in the amount of $1,341. I have had contact with the defendant and his parties, his family, indicating that they had intended on paying the balance in full. However, that has not happened yet.
Things get intense again as they argue over weekends, hours, and where to meet. Even a simple park visit turns into a full debate.
Thank you. Ms. Provan, any comments that you'd like to make or any questions that you have?
Just that the $1,000 payment that was made back in June was me writing off some of the arrearages. And she's correct. He was given the money to pay off the arrearages and chose not to do so.
Okay. All right, well, file does indicate notice was sent to Mr. Ackerman to appear for today's date and time. Given his failure to appear, I will recommend a bench warrant in the amount of $2,500 plus $100 in costs. Thank you, Ms. Provan. You're all set.
Thank you.
The matter of Mackenzie Miller versus Vinzenz Waney, file number 18-17520 DP. Do we have anyone present on that?
Yes, sir, Your Honor. Mr. Waney, I'm here.
Thank you, sir. In front of the court, what is the status of this matter?
The defendant has a monthly obligation of $461 plus $50 ordered on arrears. Current balance is $10,842.29, which does not count a $100 payment that was made yesterday. Month of September, we did receive $150. Prior to that, we received $159.77 in June. I did have a conversation with Mr. Waney yesterday, and he is intending on filing something to potentially lower his support. He is making his best efforts.
Mr. Waney, what would you like to say?
Well, Your Honor, I would just like to say that it has been quite a struggle for me, but if you give me a chance, I would like to get this taken care of. I want to do the right thing by my son and by his mother. We seem to have a pretty good friendship, and I'm just in a hard spot in my life. With my record, it's kind of colorful. It doesn't make it exactly easy for me to get jobs, but I'm doing the best that I can. And I will continue to do so.
Are you working or are you searching?
Searching for gainful employment at the moment, but right now I have several handyman jobs, cash paying jobs that I have lined up. That's nothing serious. It's not full-time work, but it's anything I can get my hands on right now.
All right, I'm gonna adjourn you out to December 3rd. It gives you 2 months to show the court some effort. When we come back then, I want to make sure that you're making payments, and I want to hear from you what efforts you've made to get employment, okay?
Yes, sir, Your Honor. Thank you.
All right, thank you. You're all set. Thank you. We have Mr. Moore present. In front of the court, what is the status of this file?
The defendant has a support obligation of $380 plus $50 ordered on arrears. Current balance is $2,015.76. Last payment received was in May in the amount of $255.57.
Mr. Moore, what would you like to say?
I'm kind of, I think we have a court case coming up for our adjusted parenting time that we did, I think about a year ago. My support was never adjusted to the, because before I had no parenting time on record, and in the last year, the support has not changed at all. So it was supposed to go lower, and it has not changed at all. And then I also had the last time I was in court with you for the support, I also put my daughter. I have a daughter I take care of at home, not with Andrea, and it was never adjusted down because I was paying. It's been the same. I believe it's been the same this whole time. But I fell on a hardship this summer, and I am working, but I just was wondering. I was kind of curious. I called in front of the court a couple months ago, and they said that if the parenting time was adjusted, it should have took it down, and it never did. It was still the 370. I think it's like 370 plus something, and then she said there's arrears, but it was never adjusted to parenting time added to my case.
All right, are you currently working?
Yeah, I am.
All right, what do you do for work?
I work at a gas station.
And you get paid in cash or you get a paycheck?
I get a paycheck.
How long have you had that job?
Little over a month.
Okay. Did you report that employment to friend of the court?
No, but I also reported that I had another child, and they didn't also lower my support either.
We have to file a specific motion to get that accomplished.
I did. I came into the courthouse after I had my court date with, I believe it was you, Your Honor. I think it was a year ago.
I know in May of 24 there was, July of 24 there was a change in the custody order, it looks like.
Yep, but there was no change in the actual, because I was paying the max amount because there was no overnights, and I've been keeping up with you. I mean, if front of the court wants to contact Andrea Servany, we've been doing our parenting time exactly how it's supposed to. But I did go into the front of the court and do the motion. I filled out all the paperwork, and they said I'd be getting something in the mail, and I never did. And I called them back, and they said that it should have been changed, and I've never heard anything.
All right. Well, I certainly don't see a motion in the file since that August or July of 24 date.
But did that lower the support for the parenting time?
It did not. I don't see a motion in the file that was ever filed.
But
so typically when you file a motion, hold on, sir. Typically when you file a motion, they give you a court date, and then you submit the paperwork to the clerk. Did you ever take that step or not?
No, I thought when we were at court, it was under the impression that there was no established parenting time, is why I was paying the max amount for support a month for my son. And then when it was established,
hold on, sir. You indicated you filed a motion. That's what I was trying to get at.
I came into the office and I filled a motion. I filled it all out, And then I turned it in, and that was the last I heard of it. And then we filled, no, because it was that's why we had the court date, was because I filled out the motion for parenting time.
All right, after that motion, I was asking if you filed anything else.
No, because I thought that's, and I thought I did more than one motion at the same time, because I did for parenting time, and I also did for lower support. And because I added on to my case that I take care of my daughter full time at home, and I have another child in the home, and I actually have two daughters in the home now. I just had one a year ago, so I'm supporting two children at home, and then I also have the support for my son that I've been trying to keep up on. It's been since May, which has been a few months, but.
All right, I do see the prior motion regarding the parenting time, as well as at that time, you did file a motion regarding support.
Yeah, so, and that's what I was wondering, nothing ever changed.
All right. Well, it's been a year, you probably should have.
Like I said, when I first got something from front of the court saying I was falling behind, and I saw how much they were still charging me, because it was coming out of my checks before May, it was automatically coming out of my check. And I thought that maybe it was because I fell a couple months behind, why it was taking so much. And then but now I got the paper for this court date, and it was showing me that my balance was at the time it was 1,600 and something. And then obviously it's a new month, so it went up.
You're exercising parenting time every other weekend and then sharing the summer, is that right?
Yeah, for every other weekend. And actually we've kind of been working with each other more about like if she needs.
All right, that's okay. You answered my question.
Yep.
All right, so but you still haven't made a payment since May, is that correct?
Correct, because I felt I lost my job where I was working, and I fell on some hardships. I was struggling to get my rent paid and my bills paid. So I got a job now, and I'm working on getting caught up.
So I do see that there was a new order obviously put into place last July that did grant some overnights for Mr. Moore. There was never a new support calculation done. So I am going to direct in front of the court to do a new calculation. They will probably send you some financial information that you need to fill out. And if you've got other kids, you got to make sure that that information is provided.
Yep, and I believe I did provide that with them for my daughter, because I had her birth certificate and everything there with me when I turned that in.
All right, sir, just slow down. All right, you're going to get sent that information, and you're going to do a new calculation.
Okay.
I'm going to have some discussions regarding the effective date, and we'll make a determination on when that would go back to.
Okay.
We're also, who is your current employer?
Blarney Castle.
Okay.
But if there's a way not to garnish my check, that would be nice. I plan on, I mean, when tax season comes, I will be caught up with everything. It'll bring it concurrent. So I mean, I can make a payment, but I would prefer it not to be garnished, because it just, it's one of those things where I don't want it to be garnished, if that's possible. I mean, obviously if I fall behind more and more, then it can be a garnishment, but I plan on.
Right, step one is we're going to do this new calculation.
Okay.
Update your.
After all that back and forth, the court finally finds a fragile truce. Both parents swear under oath to follow the order and use the parenting app to keep things civil.
I'm going to set it for a new hearing in December, so December 3rd. So by then we'll have that new calculation done, see where things are at.
Okay, now would the front of the court like me to bring in my birth certificate for my other daughter in the meantime?
That's not necessary.
Right, they don't need that, but you're certainly going to want to provide your updated income information, okay?
Okay.
All right, thank you. You're all set for today. Gary Churches versus Joshua Kilborn, file number 24-19906 DC. We have the parties present on that matter.
Yes, Your Honor. Jennifer Dusman-Coy on behalf of Gary and Donna Churches, who are present with me in my office.
Yes, I'm here.
Thank you, sir. You are Mr. Kilborn?
Yes, Your Honor.
All right, we're here today on a status conference regarding entry of the final order and the support order. Ms. Stutz-McCoy, what would you like to say regarding?
The parties had agreed back in March, actually, to the arrangement that they presently have with my clients having custody of their grandson. They have guardianship over him, that was in his best interests. And the front of the court had asked for an order to finalize this matter, so I had drafted those, sent those to Mr. Kilborn after getting approval from the front of the court. And my clients have signed the orders, but we didn't get a signature from Mr. Kilborn. But other than that, I think we're prepared to enter these orders as the parties already agreed that all of this was in the children's best interest, and there weren't any objections filed to the child support recommendation. So basically, we thought, today was kind of a technicality to get those orders entered.
Thank you. Mr. Kilborn, anything that you would like to say?
I don't think so. I just, yeah, I don't think so.
All right, are you able to sign this, to come in and sign this document?
That's the trouble I have, Your Honor. I work till 5 o'clock in the afternoon, Monday through Friday, and I work on the road, and I have a lot of trouble getting up there.
All right, well, on the record, do you grant the court permission to sign your name on the final order regarding custody, parenting time, and support?
I do.
You understand that this order simply puts into place the previous order that was agreed to back in March,
Yes, Your Honor.
which grants you some parenting time. And also has the support order, which was previously entered also. Do you understand that?
I do.
And are you making the decision to allow the court to sign your name to the document freely and voluntarily?
Yes, Your Honor.
Okay. All right, well, we will sign that and process the judgment. Ms. Stutz-McCoy, you may need to pick it up from the front of the court and then take it to the clerk's office. But I'll have front of the court confirm that.
Okay, thank you.
Yes. All right, so we'll get those signatures on there, and then you can pick it up and have it filed with the clerk. All right, anything else, Ms. Stutz-McCoy?
No, thank you, Your Honor.
Mr. Kilborn, anything else?
No, Your Honor.
All right, thank you everyone for appearing. You can sign off. And Mr. Gilder, this is your motion, is that correct?
Yes, sir.
All right. And it's regarding support. What are you asking the court to do?
Well, just recently I lost my job on September 4th, so I have the unemployment coming in, but the child support pretty much wiped out my first whole payment. So I'm asking for it to either be reduced or suspended until I can figure something out.
So the last support amount was calculated on that job, is that correct?
Yes. Yep.
Okay. And when was the last time that you worked that job?
September 4th was the day I was terminated.
Are you currently seeking new employment?
Yep, I'm working on it.
Ms. Wilson, anything that you'd like to say?
No, Your Honor.
Okay. Anything else that you want to say, Mr. Gildner?
No, sir.
All right, so when there is a change in employment, the court looks at whether or not income should be imputed based what's presented today. I certainly understand that there is sometimes a gap in finding employment, but that the support guideline does not give the court the authorization simply to reduce support to zero because employment is lost. We continue to impute that income. If you get a new job that pays less money, certainly the court can reevaluate and determine if that is the appropriate amount. But where we're at today's date, I would deny the motion. But Mr. Gildner, if you get new employment that is paying you less, you might want to renew your motion regarding support. Any questions, sir?
Well, I have one question. So since I have unemployment coming in, and it's like, I think it's like $446 a week, and that's a lower amount. I think it's like $20,000 or whatever for 6 months or whatever. How does that work? Then I just keep paying the based off of the 50,000 a year I was making off the last job?
Well, are you looking for employment or are you just gonna?
Yeah, no, I'm looking for employment, but for right now, like when the child support comes out, it's basically wiping my whole entire income out.
Yes, I mean, some of it comes down to how long you're gonna take to get a job.
Yeah, I mean, I'm
Um,
working on it, but I have felonies, so it's not like it's super easy to find a job.
Okay. I think what I might do is adjourn your motion. I know we have a court date coming up.
Yep, 15th.
So, because if I flat out deny your motion, then you wouldn't be able to go back in time. If I adjourn your motion and we reassess where things are at, any changes could go back in time. So what I'm gonna do is I'm gonna adjourn this matter to that same date on October 15th.
Okay.
And we'll get the update from you as to the employment situation, okay?
Okay.
All right. Any questions, Ms. Wilson?
No, Your Honor.
All right, thank you both for appearing. We'll see you on the 15th.
Thank you.
The court is recalling the matter of Tasha Butts versus Ronald McCluskey, file number 11-14145 DP. Looks like Mr. McCluskey is present. Good morning, sir.
Hi, how you doing?
Good. All right, I previously called your matter when it was scheduled. You were not present. Is that correct?
Yes, I get my dates mixed up. I apologize.
All right, so this matter was referred to the court after a denied ex parte order. Is that correct?
Yes.
What is happening right now as far as custody and parenting time?
Kylie's with Tasha still. She quit my parenting time a while ago when we started with Kylie in the school and stuff. And I've been in contact with the court about everything, and then I filed the motion.
All right, what change are you looking to make?
Where Kylie's with me, so she's in school, or at least more parenting time, so I can make sure she's in school full time. She hasn't been attending school or her mental health doctor's appointment or anything like that. And there's a lot of other things going on with her mother and her in northern Michigan.
All right, where do you reside?
Oakland County.
Okay. And so you were late because you had the wrong date, is that correct?
Yeah, I thought tomorrow was for some reason. I got my dates mixed up.
All right, so what changed that you knew to sign in if you thought you had the wrong date?
I called the court once I realized it.
All right, I'm not really hearing anything you're saying. Your connection is horrible. All right, but given your attendance, I'm going to change my prior decision to dismiss the motion. You weren't very, very late. And given that this came from an ex parte, what I'm going to do, sir, is set your matter for a hearing. That's an in-person hearing where you can make any arguments you wish to make as to any changes in custody and parenting time. That hearing date's going to be December 3rd at 2:30. And again, that is in person. So you need to be here in court. Parties need to file witness and exhibit list 14 days prior. Any of the children that are 7 or older need to be present that day for a preference interview 15 minutes prior to the court's time. Any questions, sir?
No, sir.
All right. Thank you. You're all set for today.
Thank you. Bye-bye.
The judge draws a firm line while both sides try to hold their ground. It's a powerful reminder that in family court, nothing ever ends quietly. Thanks for watching. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.